What I'd like to do now is invite up Kathi Grasso. Kathi is a senior attorney with the Office of Juvenile Justice and Delinquency Prevention, and she is going to provide some opening remarks. And one of the great things about Kathi is she has dedicated her professional life to improving juvenile justice. If you look at her vitae, you'll see for the past 28 years she has worked in the public sector with the American Bar Association, legal aid, and in the past 10 to 15 years as part of the Department of Justice. She's a frequent speaker around the country. She's published numerous articles, and it's an honor and a privilege to have Ms. Kathi Grasso this morning. So I would like to go ahead and welcome her. So, go ahead.
Thank you so much. Welcome. It's so wonderful to be in Texas. This is my actually second trip to Texas. I came to Texas to visit family in Houston back in the 1970s, and my trip has been long overdue. But I thank you so much for the opportunity to participate in this event. It is such an honor to address you, distinguished members of the Texas Bar, Defense Counsel, court administrators, prosecutors, judges, and so many others dedicated to providing high-quality legal services and ensuring access to justice for this nation's most vulnerable youth and adults. It's particularly exciting for me to be here because I was a legal aid attorney for over a decade. For part of that time, I managed the Child Advocacy Unit in Baltimore City, an office responsible for representing almost all children coming under the jurisdiction of Baltimore's Dependency Court. Many of those children also were at risk for or involved in delinquency proceedings. It was the hardest and also the most rewarding job that I have ever had. The Legal Aid Bureau's Child Advocacy Office and the respective courts in which we appeared were intense workplaces. We had extremely high and complex caseloads, particularly because staff adhere to high professional standards for client representation and care deeply about their clients. They experience significant stress levels. One of my greatest challenges was representing 27 children in one day. I have seen firsthand how the quality of justice is impacted by intolerable working conditions. Because of my experiences at Legal Aid, systemic juvenile court improvement, particularly addressing the needs of the juvenile defense and child welfare bar, became one of my passions and a focus of my professional activities. I want to convey to you today what we at the United States Department of Justice are doing to address positive systemic reform in relationship to indigent defense. Because I am most familiar with efforts within the juvenile justice sphere, my remarks will be primarily focused in that area. However, in preparing for this talk, I've conferred with my colleagues at the Department of Justice and Bureau of Justice Assistance, a sponsor of this event, to ensure that you are aware of the department's activities focused on adult indigent defense. We have circulated in the course materials handouts that provide you with background on Bureau of Justice Assistance programs and OJJ, Office of Juvenile Justice and Delinquency Prevention resources with website addresses so that you can easily access the information provided. My contact information, as well as the contact information from the staff of the Bureau of Justice Assistance, has also been shared, and we sincerely welcome your inquiries. As I say to the staff at OJJ, my door is always open, and my door is always open to all of you. Today, I want to convey to you the strong message that I have been hearing from the Attorney General of the United States, Eric Holder, and other DOJ leadership, that the federal government must partner with states, local governments, non-governmental organizations, and others to address the needs of clients and those working to provide people with low incomes access to justice in criminal, delinquency, and related proceedings. The Attorney General, in recent remarks to the American Council of Chief Defenders, voiced serious concern that we as a nation have not adequately addressed the crisis in indigent defense, and he called it a crisis. He asserted, and these are his words, "When I took the oath of office as Attorney General, I swore to support and defend the Constitution of the United States. Supporting and defending the Constitution includes, in my view, a responsibility to serve as guardians of the rights of all Americans, including the poor and the underprivileged. His remarks went on to acknowledge the many challenges, such as high caseloads, inadequate compensation, and overall insufficient financial resources that defenders face in addressing the needs of their clients. He voiced his appreciation for the work that all of you do, despite these numerous obstacles in providing quality legal representation. During the speech, the Attorney General went on to outline future activities that the Department of Justice would undertake to engage the indigent defense bar. In a very short time, the Attorney General has turned his words into action. I am here today because of that pledge. As he said he would in his speech, the Attorney General has begun to actively engage representatives of the indigent defense bar, including representatives of such organizations as the National Legal Aid and Defender Association, American Council of Chief Defenders, and the National Juvenile Defender Center. As he announced at his earlier speech, many of us at the Office of Justice Programs, which is a component of the Department of Justice, are planning an invitational meeting on indigent defense in Washington scheduled for mid-February 2010. The idea being that we bring together defender and others interested in addressing the crisis in indigent defense from all 50 states, the District of Columbia, the territories, and the Commonwealth of Puerto Rico to share and learn from each other. The conference will focus on both adult and juvenile defender issues and will emphasize promising approaches to implementing systemic reform with the aim of developing best practices amongst indigent defense programs throughout the country. It will also be a forum where defenders can strategize about how to get involved in the decision-making processes related to funding and find support in difficult economic times. I'm also participating on a recently formed Attorney General, Department of Justice internal working group on indigent defense, bringing together representatives of the Department of Justice entities to coordinate federal efforts to address indigent defense concerns, as well as identify opportunities for partnership with people such as yourselves. In addition to the activities just described, the Attorney General has advised that he wants to make sure that whenever the department brings together criminal justice stakeholders, prosecutors, judges, law enforcement, victim advocates, that the defense bar be included. In the past, the defense bar has not always been included. This inclusion would extend to conferences, grant application review panels, and other forums in which the defender perspective is critical to any discussion of criminal and juvenile justice concerns. He's also asked the Department of Justice to expand its commitment to collect accurate and meaningful data on public defense programs so as to be better equipped to help them. For example, the Bureau of Justice Statistics, part of the Office of Justice Programs, conducts a census of public defender offices. In the past, this census has not collected information regarding the services provided by contract and pro bono attorneys. As the Attorney General stated, we need to capture those services by surveying a sample representative of all participants in the system. Now, turning more specifically to the work of my agency, the Office of Juvenile Justice and Delinquency Prevention, also known as OJJDP, is a component of the Office of Justice Programs at the Department of Justice. Our charge is to provide national leadership, coordination, and resources in the area of juvenile delinquency, juvenile justice, and child victimization. This charge encompasses the fair administration of justice, including juvenile court improvement. Over the years, my agency has recognized early on that court improvement cannot be limited to supporting the work of only juvenile court judges and prosecutors, but also juvenile defenders. Justice is not served when youth experience no or low quality legal representation. Over the years, OJJ has supported the work of the ABA Juvenile Justice Center, and in addition, in the past, we have supported or provided funding to the National Juvenile Defender Center. Many of you may know Patty Puritz, the center's executive director, and the center's significant work in conducting assessments of juvenile legal representation in states, including in Texas, and in providing training and technical assistance to defenders throughout the nation through regional centers. She and the center staff are highly committed advocates for youth who have been courageous in their efforts to give the juvenile defense bar, I have to say, a very strong and influential voice in Washington and throughout the nation. I have to say, I understand she met recently with the Attorney General. I was not present at that meeting with a number of other public defenders, and her question to the Attorney General is, well, we need more juvenile defenders represented at this table. And that's one reason now I'm a member of the Indigent Defense Work Group. OJJDP anticipates an ongoing partnership with the National Juvenile Defender Center. Over the past several years, OJJDP has also worked closely with the National Council of Juvenile and Family Court Judges in the development of a publication or guidance entitled Juvenile Delinquency Guidelines, Improving Court Practice in Juvenile Delinquency Cases. The guidelines were published in 2005. And the staff of the National Juvenile Defender Center, the National District Attorneys Association, of course the National Council, and other national organizations were advisors to this project. It was the consensus of project participants that a key principle of a juvenile delinquency court of excellence is, and quote, youth charged in the formal juvenile delinquency court must have qualified and adequately compensated legal representation. The guidelines state, alleged and adjudicated delinquent youth must be represented by well-trained attorneys with cultural understanding and manageable caseloads. Juvenile delinquency court judges are responsible to ensure that counsel is available to every youth at every hearing, including post-disposition reviews and re-entry hearings. Moreover, the guidelines contain strong language discouraging judges from allowing youth to waive the right of counsel in delinquency proceedings. The guidelines' current phase is implementation, and you should be aware, and I have some information in the handout about this, the National Council of Juvenile and Family Court Judges currently supports a model courts initiative in which assessment, planning, technical assistance, and evaluation services are provided to courts committed to becoming courts of excellence as defined by the guidelines. This court improvement initiative includes efforts to implement the key principles of the guidelines, including regarding the appointment of qualified and adequately compensated legal counsel. I hope that in the future, the Office of Juvenile Justice and Delinquency Prevention will be able to expand on these activities. If you're not already doing so, I would certainly encourage you to educate your Texas judges, prosecutors, defenders, legislators, and others about these guidelines. They lay the groundwork and are a persuasive tool for tackling concerns within our juvenile justice system, particularly issues pertinent to the legal representation of children and youth. And you can obtain copies of the guidelines from the website of the National Council for Juvenile and Family Court Judges, and that information, as I said, is in your packet. I would also note that the Federal Advisory Committee on Juvenile Justice, a group comprised of the 50 states, the District of Columbia, and the Commonwealth of Puerto Rico, and the territories, that advises the Office of Juvenile Justice and Delinquency Prevention, the President, and the Congress, has voiced strong recommendations that my office, OJJDP, address the legal representation of children in delinquency proceedings. And copies of this committee's reports can also be downloaded from the OJJDP website. I want to alert you not only to court improvement related activities just described, but also to the vast array of federal resources that can inform your individual representation of clients as well as systemic reform efforts. Many of these resources are presented in your course materials. My office supports training, research, and technical assistance, including the ongoing development of a model programs guide, where you can actually access information about what works and what doesn't in terms of programs. I often say to myself when I became aware or started working at OJJDP and OJP's resources, how helpful this information would have been in my individual representation of clients. It really struck me, oh my God, how little I knew sometimes about evidence-based programming for my clients. And of particular note are the many publications of my office and the National Institute of Justice and others. For example, you should be aware that OJJDP published a publication in 2008 a bulletin presenting findings on research relevant to the waiver of youth to the adult criminal justice system. The bulletin points out many concerns about the effects of that waiver on youth policy, on recidivism rates, and that sort of thing. I also like to point out, too, and I don't have this in my handouts, that the Centers for Disease Control actually also issued a report on this very topic, recommending against policies of waiver of youth into adult criminal justice systems. So I'd highly recommend going to their website, and if you want more specific information about the CDC materials, I can certainly provide that to you. In addition, and most importantly, OJJDP performs a regulatory function in overseeing state compliance with the Federal Juvenile Justice and Delinquency Prevention Act. And defenders should be knowledgeable about the core requirements of the JJDP Act that prohibit youth contact with adult inmates and the inappropriate incarceration of status offenders. The Act also requires states to address the issue of disproportionate minority youth contact with the juvenile justice system. Regarding other Department of Justice programs, as I've already mentioned, I would direct you to your course materials. Bureau of Justice Assistance staff have summarized their agency's indigent defense programs, including a grant recently awarded to the American Bar Association's Standing Committee on Legal Aid and Indigent Defenders to provide training and technical assistance to public defenders across the nation. Other Bureau of Justice Assistance programs address defense hiring, sharing best practices, capital case litigation, and wrongful prosecution review. And likewise, the National Institute of Justice, their website has critical information for you on its DNA initiative. The address is very simple to remember, www.dna.gov. The website provides an overview of funding, training, and technical assistance to ensure that forensic DNA reaches its full potential to solve crimes, protect the innocent, and identify missing persons. I also want to acknowledge that later today, you will hear from BJA's partner at the Criminal Courts Technical Assistance Project at American University on effective criminal caseload management. I know that this team will provide an insightful program that will be a benefit to you in your work. In closing, our greatest potential for producing lasting change lies in focusing our energy and resources on our nation's children, youth, and families. The creation of the juvenile justice system more than 100 years ago was predicated on the belief that virtually all youth, with proper support and adult nurturance, can become productive, successful members of their communities. Meeting the legal needs of youth in the juvenile justice system is both compassionate and cost-effective, as well as critical to the underlying mission of this nation's juvenile courts. In working with you and others, OJJDP and the Justice Department seeks to honor the mandates of Gideon and In re Gault. All children and youth are deserving of and should be afforded high-quality legal representation. I really look forward to learning more from you about how we can best implement the full array of principles set out in the Juvenile Delinquency Guidelines, as well as those enunciated in national and state standards relevant to adult indigent defense, or adult defense generally. I hope that new opportunities for collaboration between the U.S. Department of Justice and audience members, can be forged today. And most importantly, I thank you for all that you do to ensure that those individuals in need are afforded access to justice. Thank you.